In 2021, when an employee, dubbed Employee 2, was sitting in his truck at the ExxonMobil refinery in Baytown, Texas, he heard, saw, and felt a large explosion. While coworkers and their attendant rescue personnel were evacuating the explosion site, 2 raced towards the fire. He was a process technician, not an emergency responder. Still, with the help of firefighters, he donned a fire suit and he guided firefighters throughout the blaze to several valves that needed to be shut off. At the end of this ordeal, 2 met with Exxon grief counselors to discuss the anxiety he felt afterwards. He saw several doctors, all of whom diagnosed him with post-traumatic stress disorder, or PTSD, and all of whom sent their written diagnosis back to ExxonMobil. ExxonMobil decided that it was not a recordable injury or illness and did not enter the event into their OSHA Form 300. 2's union reported this to OSHA. OSHA issued a citation for failure to comply with the OSHA injury and illness record-keeping rule. This case went all the way to the U.S. Court of Appeals for the Fifth Circuit. Today, we're going to discuss the Fifth Circuit's decision, a critical OSHA standard whose fate hung in the balance of that decision, and what it means for employers everywhere. I'm Manesh Rath, and this is the August 2026 edition of the OSHA 3030. Well, hello, everyone. I'm Manesh Rath. Welcome to the OSHA 3030. For 31 years, I've been representing employers in the field of workplace law, particularly with a focus on occupational safety and health law. I've been doing this out of our Washington, D.C. office, and I'm grateful because I'm joined today by my good friend and colleague, Victoria Tinker. Victoria, welcome to the OSHA 3030.
Manish, thank you for having me.
Well, I think this is a really important topic, and I think it's an interesting opinion.
Yes.
We're going to start by talking about what we're going to talk about. First, I think we should get into the facts of the ExxonMobil case, which is styled as ExxonMobil Corporation versus the Occupational Safety and Health Review Commission, and then get into some of the backgrounds of the OSHA record-keeping rule requirements.
That sounds good. And then we can talk about the OSHA citation and its arguments, ExxonMobil's reasons for not recording the incident, the Fifth Circuit's decision, and then I'll hand it over to you to talk about what employers should be doing in light of this decision.
Right, those practical takeaway items that we think are the most important part of this program. So stay tuned. This is a pre-recorded event. We'll also be posting it as a podcast as well as on our website through a YouTube video that'll have both the slides and live video, as with all of our prior episodes. So please take time to look back through the Keller and Heckman library of OSHA 3030 episodes going back 13 years, over 150 episodes, almost all of which are still very informative to this day. And subscribe to the podcast. And please, as you may recollect, I've asked every time when you get an email invitation to the next OSHA 3030, please forward it on to at least 3 others, both within your organization and at other organizations, both safety and health professionals as well as your in-house counsel responsible for compliance with OSHA laws. All right, well, why don't we crack on? The facts of the case are really important, but the case really turned on a question of administrative law. So in December of 2021, in Baytown, Texas, Baytown is a very large ExxonMobil petroleum refinery. I've handled OSHA enforcement actions at the Baytown facility, and it's just an enormous facility with lots of activity, lots of employers. Well, repairs were going on at one point in December of 2021, and a pipe burst, and this burst pipe caused a large explosion and then led to a conflagration, which led to a fire that lasted over 8 hours. The destruction was so vast that it took ExxonMobil over 5 months to restore the damaged property at the refinery. Employee 2, as we mentioned at the beginning, rushed to the fire, and firefighters outfitted him with a fire protective suit, and he led them through the fire to several locations where there were shutoff valves, and they were able to successfully shut those off. 2 came out, doffed his fire suit, was recovering, and then was informed that the fire was still being fueled somehow, and there must be some other valves that need to be shut off. He redonned his fire suit and went back into the fire and led them to several more valves that were shut off. Even after those valves were shut off, the fire continued to burn for several hours just from the fuel that was in the system beyond the valve points. And they just had to wait for it to burn. After the event, two came back and met with Exxon grief counselors.
hmm Yes. So he met with that on-site grief counselors, and then he met with a licensed clinical social worker in one practice, met with another licensed clinical social worker within the same practice. He met with his primary care physician, and then he met with a mental health therapist, all of which diagnosed him with a textbook case of PTSD.
Yeah, those were their words. They said this is not only post-trauma stress disorder, this is a textbook case of it.
Yeah.
Some of these doctors were doctors that employee two found through Exxon's EAP program or were listed in their list of physicians through their EAP program. He met with a psychotherapist, his own primary health care provider. So there's no doubt that these were all properly described as healthcare providers, certified or licensed healthcare providers. And there's also no doubt that, at least in the case of the EAP doctor, that this was a doctor on Exxon's approved list. So these are critical facts going into the question that Exxon faced, which is whether this PTSD was a recordable event under the injury and illness record keeping rule.
Yes. So Exxon did receive the medical records from all of these healthcare professionals and sent it on to their risk management team that determined that these healthcare professionals were not qualified to diagnose recordable work-related illnesses. The employee, dubbed Employee 2, met with doctors in Exxon's Employee Assistance Program portal and was also diagnosed with PTSD.
So now that would have been the second opinion,
Yes.
according to 2.
Yes.
He said, I've gotten the first doctor from the EAP program and now a second doctor from the EAP program, plus the psychotherapist and my own primary health care provider. But at least that second one from the EAP program was approved by Exxon and a second opinion.
Yes, and I think it's important to note that all of these healthcare professionals that Employee 2 met with were licensed in the state of Texas to diagnose post-traumatic stress disorder. So when Exxon received this paperwork, it sent it to its own physician, which concluded that Employee 2 did not have PTSD.
What happened there, Victoria, I think you'll recollect, it was interesting that they asked Employee 2, we'd like you to get a second opinion with a physician of our selection.
Yes.
And so we want you to go to this physician here. And 2 refused, saying, I've already gone to get a second opinion. That's already been done. And so Exxon sent the paperwork to this physician of their own selection.
Mhm.
And the physician, merely based on the paperwork, was able to draw a conclusion that 2 did not suffer from PTSD.
Yes, they never met in person, just based on the paperwork.
On the basis of that second opinion, what Exxon described as the second opinion, Exxon made a determination that this was not a recordable event.
Yes, for the OSHA record-keeping requirements.
Right.
Exxon did have an internal disability report that it did document this incident with, but it did not fill out OSHA Form 300 and the accompanying 301 form.
So why don't we step back and talk about the OSHA record-keeping requirement as it applies here? This emanates from the OSHA Act, which directs OSHA to create a record-keeping rule, the purpose of which, according to Congress, was developing information regarding the causes and prevention of occupational accidents and illnesses. So the more data you gather, the more you can divine patterns in the data. And that was the original purpose of Congress putting it specifically in the OSHA Act, directed the agency to develop a record-keeping rule.
Yeah, so OSHA did promulgate a standard that stated mental illness will not be considered work-related unless the employee voluntarily provides the employer with an opinion from a healthcare professional stating that the mental illness is work-related, and that's CFR 1904.5 subsection B29.
So the standard, which describes a lot of things, it's an interesting standard in its revision. It was done in a question and answer format or frequently asked questions format. And one of the questions was about recordability. And one of the subsections of that question dealt specifically with mental health. And that's the one you're describing here. OSHA said in that specific subsection that mental illness will not be considered work-related, with the exception of a scenario where the employee voluntarily provides the employer with an opinion from a certified healthcare professional stating that there is a mental illness, and B, that mental illness is work related. So that standard now has been promulgated through proper rulemaking, administrative law notice and comment rulemaking under the OSHA Act, and has been on the books for many years now. And employers have been relying on that specific standard that mental illness will not be considered work related unless the employee voluntarily provides the employer with an opinion from a healthcare provider. And that really becomes the subject, I think, of the Fifth Circuit scrutiny.
Yes. So the dispute stems from ExxonMobil's position that this statute does not include mental illnesses. And OSHA's argument to that is Congress granted OSHA with the power to require recording of work-related illnesses, deaths, and injuries. OSHA, in its brief, pointed to legislative history suggesting that Congress was concerned with both physical and mental workplace harms. OSHA did highlight that the broader purpose of the OSHA Act is to ensure safe and healthful working conditions. However, as we'll get to the court's decision later, didn't find it persuasive.
It's interesting that they cited to the congressional record, which is really next level argumentation, and it happens a lot in trying to understand what Congress intended. If the debate is whether Congress intended to grant this power to OSHA, then the congressional debate would be of some interest, I think. And they did cite to the congressional record, and in the congressional record, there is some evidence that maybe they were considering mental illnesses as fitting within the larger umbrella of illnesses. And the court stated that although the congressional record is informative, it's not dispositive. We're not required to treat that as law. The law gets reduced, the debates get reduced into a statute, and the statute merely needs the congressional record to shed light on it if there's an ambiguity. And here they didn't see the need to go and give any weight to that congressional debate.
Yeah, that's correct. They focus really on statutory interpretation, and that's in a Loper Bright world where I think a lot of these cases are going to turn.
Right. Well, why don't we talk about OSHA's argument? So OSHA said when you look at the legislative history and Congress's intent, Congress wanted us to regulate the recordability of injuries and illnesses, and we think mental illnesses are included in illnesses, and we think there's good evidence to support that. Exxon's response as to why it didn't record this particular event for two was, well, we relied on the second opinion. We have a right under the rule to get a second opinion and interpretive guidance, and we exhausted that right, and the second opinion said it wasn't recordable, and we relied on that. That was Exxon's argument, and yet the court didn't really issue an opinion that hinged on that argument, on the question of whether or not Exxon was correct or defensible in relying on that second opinion. It really went to the question of whether or not mental health illnesses are recordable, or whether Congress intended for them to be recordable when conveying to the agency the power to promulgate a record-keeping standard.
Yeah. And that's where the Fifth Circuit came out. The Fifth Circuit decided that the OSHA Act leaves the term illness undefined. The context in which illness is used seems intended only to cover illnesses that are physical ailments, minor injuries. The court pointed to the minor injuries exclusion that addresses only physical, not mental harm. The court cited evidence that medical treatment of consciousness, restriction of work or motion or transfer on the job is really what the OSHA Act is focused on. And just because the term illness does not specifically include mental illness, that doesn't mean that OSHA can pull that in. It has to stay within its lane of congressionally delegated authority.
Yeah, I think that's right. And I think one of the things that the court looked to was the full language of both the act and the standard, which talks about deaths, injuries, and illnesses, and describes that phrase as creating a separate category for deaths and a separate collective category for injuries and illnesses, and then goes to the minor injuries exclusion and considers that the way the minor injuries exclusion is written, it looks like all injuries and illnesses to the court appeared to be those relating to physical ailments of one sort or another, because the minor injuries exclusion, the court reasoned, just described or included instances that involved only first aid and not medical treatment, loss of consciousness, restriction of work or motion, or transfer to another job. And it reasoned that where illness was concerned, all of those would have required an illness that had a physical impact, a physical ailment, and not a mental illness. And so, by that reasoning, by looking at how the minor injuries exclusion was describing only illnesses with physical impacts, they believed that mental illnesses weren't covered in the prime sentence of the rule, which is that injuries and illnesses should be recorded. So that was a part of their reasoning, and I think that it makes sense to me. I think what they're saying, but I don't know that interpreting the use of the word illness in the exclusion necessarily dictates that imply the scope of the word illness in the prime sentence. It is theoretically possible that illness was meant to cover both physical and mental illnesses by Congress's intent, but that minor injuries could be excluded and could theoretically only affect injuries and illnesses that had a physical impact. It's unknowable what Congress intended or had in mind at the time, and the best the Fifth Circuit could do is look to the existing language for hints or indicia of what it thought Congress's intent was. All right, well, that was the decision. So what they essentially did in this rule was strike that regulatory provision that stated that mental illnesses shall not be presumed to be work-related unless there's a voluntary provision of a healthcare provider certificate. The effect of which is that OSHA now has a standard on the books that, at least by the Fifth Circuit's opinion, is unenforceable. And it is the first time in many years that OSHA has had a judiciary decision striking one of the lines of one of its standards. It certainly happens. It happens across several agencies, but I would say that in the field of OSHA law, it's rare enough that I think it's exceptionally newsworthy. What happened was, years and years ago, OSHA promulgated a record-keeping rule after going through notice and comment, and now, many years later, one of the lines of that rule has been struck by one court, the Fifth Circuit. And I think that is of significant newsworthiness here at the OSHA 3030 and for you in the OSHA 3030 community. So let's talk about what we think employers should do in light of this decision.
Mm-hmm.
Well, I think the first thing to do is for employers to go back and review their current written internal procedures for recordability of illnesses, and to review the determination criteria for recordability. It may be that there is an opportunity to revise your written procedures depending on how your individual procedures are written based on this decision. I should point out, though, this is a decision from the Fifth Circuit.
Yes, and you pointed out that it's binding in the Fifth Circuit, but purely advisory elsewhere. So I think something to keep in mind for employers is this challenge going to come up again in a different circuit? Is this going to come up in a more liberal jurisdiction like the Ninth Circuit? I can see a world where this case hasn't settled all questions related to how employers maintain OSHA compliance relating to mental health illnesses and workplace incidents. So do you think that this is going to come up again?
Yeah, I think it might, because I don't think there's any reason for the agency operating in the Ninth Circuit or the Fourth Circuit, for example, or any other, to view this decision as mandatory upon them or stripping them of the enforceability of this specific provision of the regulation in those other jurisdictions. Let me be clear, by the way, folks. The Fifth Circuit, the U.S. Court of Appeals for the Fifth Circuit, is the federal court of appeals for a territory that includes Texas, Louisiana, Mississippi. And if I mention other circuits and you have questions about which circuit you're in, by all means, shoot me an email and I can help you out. Victoria, you mentioned the Ninth Circuit, and that would include most prominently California, Oregon, Washington, but also Nevada, Arizona, Idaho, Montana. I mentioned the Fourth Circuit, which includes Virginia, my own Commonwealth of Virginia. So all of these other circuits haven't weighed in on this decision, and OSHA in those area offices operating under those circuits could take the position that the Fifth Circuit opinion doesn't strip the agency of its enforceability, of its enforcement powers with respect to this sentence in the standard in those other jurisdictions. That is a possibility. Now,
Mhm.
in addition, there's 22 state plan states and a few others that are state plan states on a limited scale. And those state plan states, it's not necessary for those state agencies to view the Fifth Circuit decision as binding on them as well.
Mhm. And I did have a question about what distinction should employers keep in mind between OSHA record keeping requirements and potential employer obligations concerning workplace mental health?
Mental health generally, I think that what the basis for the Fifth Circuit's decision might have been was implicitly or as a premise was that maybe Congress didn't contemplate giving OSHA the authority to regulate mental health generally. But that is, I think, reading deeply between the lines. All the Fifth Circuit actually spoke to was the record keeping rule and the recordability of mental illness conditions and the presumption that they are not work related unless an employee voluntarily supplies a healthcare provider certificate. So that would go strictly to the question of should we record or should we not record this instance of an injury or an illness. But as I say, I think the premise, the logical premise that the Fifth Circuit rested that opinion on was the idea that did Congress intend for the term illness to include mental illness when dealing with workplace safety and health? And I thought when I read the opinion that the Fifth Circuit believed that Congress hadn't had that contemplation or consideration in mind when promulgating the act. And if
Mhm.
that's true, and that has yet to be tested, I think, then I think this would affect the agency's outreach in all dimensions with respect to mental health. And there are a few only off the top of my head, just ranging across the field of occupational safety and health law. I would say that OSHA has promulgated a guidance sheet on stress in the workplace. There's a guidance by the Occupational Safety and Health Administration on suicide prevention in the construction industry. Suicide as an incidence rate of incidents in construction is exceptionally high, one of the highest. Um, I think construction is only 7.5% of the American workforce, but almost 20%, maybe 17 to 20% of all suicides in the workplace are in the construction industry. So it turns out to be something like 4 to 5 times higher than the suicide rate in construction is 4 to 5 times higher than the suicide rate in general industry across the board. And so OSHA has issued a guidance sheet on noticing and being aware and taking steps to address employees when they think employees might be at risk. But they haven't regulated any of these issues. And then the third thing I'd think of to talk about OSHA's foray into the field of mental health is when it comes to workplace violence, OSHA has taken the position that mental health care facilities have a particularly high exposure rate for employees in mental health care to workplace violence, and a lot of that violence is promulgated by the patients in mental health care facilities or outpatient services generally, any kind of service that is a service to mental health patients. And so those are, I think, affected in the penumbra of this decision. But I would also point out that that last category, when it comes to workplace violence, really just goes to the statistical probability of workplace violence. And I think OSHA may decide to continue to proceed on its current position, which is that workplace violence is within the sphere of enforceability for the agency, and that deals only with workplace violence, and that it's the mental health care industry where there's higher exposure rates, and that's merely a question of influence on exposure rates and not mental health itself as a regulatable sort of illness.
That's right. Yeah. And I think that pairs well with the point that this is just a Fifth Circuit decision. We're going to have to keep in mind what other circuits do. And if this continues to come up, I know I'm going to be watching the progression of this issue.
I have a question for you, Victoria. I
Okay.
think that the U.S. Supreme Court issued a landmark sea change in administrative law. You mentioned it earlier, Loper Bright.
Yes.
What do you think is the relationship between the development of the Loper Bright decision and this Fifth Circuit decision? And do you think that that implies that we're likely to see more of these kinds of decisions coming out from varying courts with respect to OSHA standards of any type.
I think so. I think this is a really great example of how Loper Bright is allowing courts to sort of step into the lane of regulatory authority, where previously OSHA was the preeminent authority on workplace health and safety. Now, the Fifth Circuit has stepped in and said, actually, OSHA, you're not interpreting the rule that you promulgated correctly.
Or interpreting what Congress wanted you to do correctly.
Yes, and they're sort of tamping down OSHA's power. And I think, in a pre-Loper Bright world, we're seeing a completely different outcome to this case. I think this issue would have received agency deference, but here it is the court stepping in, interpreting the statute and the regulatory power. And it's really interesting to see how courts are really looking specifically at, did Congress delegate this authority to you? Yes. Okay. You're in the clear. No. Okay. The court is stepping in. It is interpreting the regulation. It is becoming the regulatory authority in some sense.
Yeah, I think that's right. I mean, you look at the National Federation of Independent Businesses decision by the Supreme Court together with Loper Bright, the Supreme Court decision. It's not just a question of whether Congress had delegated the authority to the agency, but the Supreme Court wants to see clear textual evidence that Congress has clearly delegated that authority.
Yeah.
Otherwise, especially if it's a major question, the Supreme Court is going to be very skeptical that the agency can merely appropriate that authority for itself interpretively.
Yes. And because you mentioned major question, I'll just note it really quickly. I thought it was interesting that neither party raised the major questions doctrine here. And as someone who is in administrative law all the time, I thought it's maybe a missed opportunity. So it'll be interesting to see if this comes up in a different case.
The next case, and that's all the more reason why you should stay tuned to the next episodes of the OSHA 3030. We're going to have a couple of our sister programs coming up soon. The Reach 3030 comes on at 10 a.m. Eastern on August 26th. And the Tosca 3030, our ongoing series relating to Tosca law, will announce its next dates shortly, always at 1 p.m. Eastern. Two excellent programs. If your organizations are subject to the regulatory schema under Tosca or Reach, by all means, follow through with finding those dates, registering for those programs. Our program, the OSHA 3030, will come on again September 16th, 1 p.m. Eastern, always on a Wednesday, always at 1 p.m. And we look forward to seeing them. But when you get the invitation for that September 16th, 1 p.m. OSHA 3030, remember to forward it on to 3 others within your organization and without, in-house counsel as well as safety and health professionals. We're always grateful to you for doing so. We hope that you continue to find 3 more and 3 more yet still additional names to keep forwarding this on to, because that is the lifeblood of the program. And we're thankful to you for that. On behalf of all the great staff who've helped put this program on today here at Keller and Heckman, and my friend Victoria Tinker, thank you for joining us. And on behalf of myself as well, thank you all for joining this month's OSHA 3030. We look forward to seeing you again next month. And until then, stay safe.